but it seems that your mandate is to defend General Booysen at all costs.
Killing a suspect is a form of resolving a case. Those were the words of Advocate RELIED. And I'm not going to lie, I'm so shocked that a full prosecutor, an advocate of the High Court, believes that a person being killed, being unalived, is a way of resolving a matter. What type of behavior are these prosecutors trying to encourage? In this video, I wanted us to talk about what is going on at the Nkabinde inquiry because it's so interesting to talk about.
Legal sense, at least, because me and you are lawyers. What does it mean to resolve a case?
It means that you are found a murderess of Chauke.
Even before you go to court, you resolve a case.
It can happen.
How?
If a case is investigated and you found suspects, and for various reasons the suspects are no longer there, that basically means that the matter has been resolved.
The suspects are no longer there. That's what you're saying?
The suspects are no longer there in order to enroll the matter on the High Court roll. They're no longer available.
Because they've been killed.
That is correct, ma'am.
You may proceed. No.
So to those who've been following me, I've been summarizing the Nkabinde inquiry with many of my episodes in this channel. And I think you guys, if you want to know about other witnesses, I encourage you to go and watch some of those videos where I break down the testimonies of some of those witnesses. In this particular video, I want to specifically focus on the testimony of Advocate Chauke and also the testimony of Major General Mabula, as well as Advocate SHARLEEN. So I'll start with Chauke. So Chauke, because for us to understand this whole thing, there is two cases, right? And they are concerning racketeering. So it was the case of MDLULI and there was the case of the Cato Manor unit. And they're challenging Chauke's prosecutorial decisions with regards to those two cases, right? And I'll start specifically with the Cato Manor unit. And I will go through all these testimonies regarding the Cato Manor unit because that's the bulk of the testimony right now, where they focused the most. And MDLULI is just a small portion, but we'll also deal with it later on. Let's first start with this particular one of Cato Manor unit. So there's people that don't understand what is racketeering and what does racketeering mean and what does it entail. Because it is you understanding racketeering where you'll understand the errors that have been made either by the KORK panel, which also comprises of Advocate RELIED, or the decisions that have been made by Advocate Chauke. You as the audience, you will decide who you think is actually guilty in this particular matter. So racketeering is normally this thing that is called guilty by association, but this one is on another level. It's on steroids. So what normally happens in this racketeering case is that, for example, in the cases of a car theft, right? You are charged with theft. But poker is designed to catch the big bosses. The people might not be stealing the cars themselves, but are running the whole operation. That is like an example, right? So for example, so under the poker, which is the Prevention of Organized Crime Act, the poker says that the police first have to prove that there's an enterprise. This isn't necessarily a legal business. It's any group of people, gang organization, working together over time. For example, a group of people who constantly work together to sell hacked gaming accounts or hacked YouTube accounts, for example. You can't usually get hit with a racketeering charge for a one-time mistake. Poker looks for a pattern of racketeering activity. So you do this thing over and over again. So it means that at least two specific charges, for example, robbery, fraud, or drug stealing. So those are some of the examples, right? So they call them predicate charges whenever we talk about racketeering. They're the ones who give rise to racketeering when you look at the predicate offenses or charges, right? So it shows that the court that it shows the court that this isn't just a random crime. It's a lifestyle or a particular business model. So actually, racketeering itself happens when you, for example, manage or supervise an enterprise through crime activities, get money or property from the crime, and knowingly participate in the group's criminal activity. Then when you look at the Poker Act, in a normal court case, the proceedings has to stay very focused on one specific crime under the poker rules. For example, the court is allowed to look at your entire history and who you hang out with to prove the part of the criminal firm. Because the government hates organized crime, the jail time for racketeering is massive, often much higher than the original crime itself. In South Africa, it may lead to life imprisonment or a fine up to 1 billion rands. So poker allows the government to take away your house, your cars, and your lifestyle if they think you've brought them with dirty money even before you are fully charged. So that is what is going on in this particular case. So we have Advocate Chauke. Advocate Chauke decided to actually charge the Cato Manor unit. So the biggest issue before we can understand the charge is the issue of jurisdiction. So Chauke is a DPP, a Director of Public Prosecution in South Gauteng. But the Cato Manor unit, we know that it's in KZN, and now he was delegated. And from his testimony, he says that he was actually asked by the Director of Public Prosecution, the National Director of Public Prosecution at the time, who asked him to go and oversee or coordinate the work that was done there by the Cato Manor unit and the Director of Public Prosecution at that time with Advocate, which is Advocate Mlotshwa. But Advocate Mlotshwa felt like that was an encroachment without his knowledge. And they didn't know that actually this person was asked to go and coordinate. And in terms of the NPA Act, you actually can be tasked to go and actually do a particular duty in someone else's jurisdiction.
Now, a blanket characterization of the DPP from one jurisdiction cannot do work in another jurisdiction is legally flawed. Consequently, the same scenario that in the DPP KZN, I was overseeing a matter, not the division of the DPP in KZN. It was a specific matter which my understanding, and in terms of the NPA Act, section 20 subsection 3, I think that the NDPP has got the powers to delegate responsibilities to a DPP, which is not expressly excluded in the jurisdiction. My understanding is that even then, Advocate Jiva did not delegate me to make decisions in respect of the matter that was based in KZN. And I do not know how she came to that conclusion that I made the decisions, because the record is very clear. I made no such decision.
But this decision was communicated by the prosecuting team, and Chauke oversaw the matters, and Chauke did not make prosecutorial decision. Very, very important. But now, unfortunately, according to the KORK panel, they don't see it like that. They think that he encroached and actually took prosecutorial decisions. So Abo Booysen, they've done a lot of unlawful acts. If you've been following this channel, you know the cases by cases of the things that the Cato Manor unit was doing under the supervision of Johan Booysen. And they decided to actually prosecute him. And later on, these charges were dropped. And it looks like they were dropped without even consulting all the prosecutors that are involved in this case. And the person at the center of dropping the charges was none other than Advocate Shamila Batohi. Shamila Batohi is a former National Director of Public Prosecution. She's currently on her pension. And it looks like everything is just on her as a person who relied on opinions for her to reach to a point that actually Chauke has to be found guilty, or they create this commission for the misconduct or the unlawful conduct or encroaching of certain decisions, prosecutorial decisions that were taken by Chauke, especially in relations to the Cato Manor unit and the MDLULI case.
Scenario in which Dr. Broughton writes in a report that you gave an instruction to Mr. Mlotshwa to sign an indictment. You also have another scenario in which there is a finding by the Mohoro Commission that you attempted to force Mr. Mlotshwa to sign an indictment. But there is no factual foundation for any of these things anywhere.
Indeed, there's not.
Yes. And then you have the evidence leaders here just repeating the line, just repeating it without verification whatsoever. Then you have Advocate Batohi just repeating it as well without any verification whatsoever. When you go to the underlying documents, you find this is a big lie. What do you say to that?
The state capture narrative, Chair, is what is at play. People have to find a reason to try and justify that narrative that there is something untoward that these people or this person is doing, especially in respect of this Cato Manor matter. That is in essence what it is, so that you can justify that people were acting improperly, inducing, forcing some people to do that which they are not supposed to do.
So now, with this jurisdiction, as I've said, this person has the powers to do so. So it was actually Advocate Jiba who actually allowed Chauke to come and take these prosecutorial decisions. And Jiba requested Chauke to sign, because there was an indictment that was signed for them to continue with the review of these particular charges so that they can be reinstated again. And this indictment was signed, and he says that, but that's the thing, Mlotshwa was saying a different thing. Mlotshwa was saying that he was forced to sign the indictment. And this one, he says it was not justified. So that's where the prosecutorial decisions by Chauke come in. The fact that he made errors with regards to that, because he made someone who was the DPP in that particular jurisdiction to sign an indictment that he did not want to sign.
The factual foundation for all of this that he is recommending is that you tried to force Advocate Mlotshwa to sign an indictment. Remember that?
Yes.
Yeah. Now, that submission was made here in this inquiry, and I asked the evidence leader who was cross-examining Advocate Mayem to show us where Mr. Chauke is attempting to force Mr. Mlotshwa to sign an indictment. You remember that?
Yes.
What did the evidence leader say?
He said, no, there's no way that it's the case, and he withdrew.
Yes, he withdrew his version.
Yes.
Now, when you look at the actual affidavit of Mr. Mlotshwa, which is what the chair was talking about,
yes,
at 6A/6, yeah. Read everything there and read it aloud, and show me where there is a line that says Advocate Chauke forced me to sign an indictment.
Let me read it for the record.
Yes.
I, Cyril Simpiwe Mlotshwa, with ID, hereby state in English that I'm currently employed by the National Prosecuting Authority as a Deputy Director of Public Prosecutions, and I'm stationed at the Office of the Director of Public Prosecutions, Peter Marisbeck, KwaZulu-Natal. On 17 May 2010 until 9 July 2012, I was acting as a Director of Public Prosecutions, KwaZulu-Natal. Between January 2012 and March 2012, while driving to Potchefstroom, I received a call from Advocate Nomgcobo Jiba, who was acting as the National Director of Public Prosecutions at the time. She informed me that there was a matter where, because of pressure, we had to enroll as a matter of urgency. I informed her that I would first read the dockets and make a decision accordingly. She stated that the matter was urgent. I responded that I did not have prosecutors to urgently look at the dockets. She informed me that because she was at the OR Tambo Airport, she was going to call me later. She did not call me later. A few days later, I received a call from Advocate Chauke informing me that he had been instructed by Advocate Jiba to send a team of prosecutors to prosecute the accused in the Cato Manor case. He told me that there were very sensitive security issues surrounding the matter. I told him that I was going to attend the DPP's meeting at VGM on 29 May 2012. So we were going to discuss the matter further.
So if you just stop there now, in the conversation you held with him, is there anything here where Advocate Mlotshwa says, in that conversation, Advocate Chauke told me to sign an indictment?
No.
And that's the thing, guys. What makes this whole thing insane is the fact that there is judgments with regards to this particular case of the Cato Manor unit. There's a high court judgment that allowed for the prosecutor to continue with the reinstatement of the Cato Manor unit charges, despite what the panel have said. But that's the thing, with Shamila Batohi and the KORK panel, they didn't care what the courts have said. They just wanted to move with what they felt and what they thought was right. And that was for them to continue thinking that the decisions that were taken by Chauke were unlawful, overlooking the decision of the High Court.
S versus Namdo Bojiba, Silverton case 622/10/2014. The case has to be dealt with in terms of Part A, prosecution of certain categories of persons, NPA Policy Directives, Paragraph 6C. I decline to prosecute Advocate Namdo Bojiba in all the charges preferred against him. The reasons for my decision are fully contained in my opinion. Now, the reason I ask you this is because you are now accused in paragraph 180.8 by Advocate Batohi of complicity in an offense that she knows was not a prosecute by Advocate Tenga.
Yes.
How do you explain that?
The desperation with the narrative that should find favor in respect of that I'm guilty of some conduct, or that's what is at play.
And she does so in circumstances where she does not take the panel into confidence and explain that I actually know that in 2015 this was not a prosecute.
Indeed.
So here the biggest role of Chauke is to give advice, right? His role is to give advice to Advocate Jiba as to what should happen, sort of like a supervisor of the decisions. But at the end of the day, it's Advocate Mayema, who was the DPP, that had to make the prosecutorial decisions and not Chauke. But it's so funny that Batohi never even went to read these papers or these dockets for her to decide if whether indeed these opinions that she's relied on to go to the president for this commission to be formed regarding the unlawful conduct of Chauke. She failed to read the papers herself. She just relied on some shady opinions that have a lot of loopholes, and it was exposed on Friday during the testimony of Advocate Riley that these people did not even know what they were doing at all. And to a certain degree, there was some racism. But let us continue, guys, with actually the reports of the KORK panel. More than anything, what you should always remember at the back of your mind is that from what has been made by Advocate Chauke is that there was a lot and overwhelming evidence, prima facie, against the Cato Manor unit. So they had to do something about it. And Jiba actually defended the review proceedings and actually went to appeal, and Ngasana then decided that the decisions that were taken by Chauke were unlawful after the appeal processes, which then led to the withdrawal of the charges against the Booysen and that non-disclosed settlement that we don't know of how much did Booysen received from the NPA as a way of appeasing him, right?
We have the national director of the NPA who then asks for advocates to essentially redo all of the work that has been done by the High Court.
In order to find a reason to justify the withdrawal of the case against the accused.
Yes, well, yes, that's the ulterior motive. But assuming there is no ulterior motive, I'm just talking purely in terms of the legal hierarchy in this country. What you've got a judgment. It's a full bench judgment. It goes thoroughly into the contents of the docket. Then it comes to the conclusion that there was evidence, and it summarizes that evidence. And then it says, based on this, there is no malafide or irrationality on the part of Advocate Jiba in authorizing the racketeering. The court has made that pronouncement. One would have expected that the NPA, being an organ of state bound by the Constitution, would regard itself as bound by those findings.
Indeed, I accept that. And it's highly improper that you second-guess the courts by trying to investigate that which they've decided. If you are not able with the findings of the reasoning of the court, the issue is to appeal.
Yes.
So in terms of South African case law, you can't take decisions. For example, I think it's the DA case versus Zuma. You can't take or decide to withdraw charges without involving the prosecutors. And that's what Shamila Batohi did. She decided to withdraw charges against the Cato Manor unit and Booysen without even consulting the necessary prosecutors that have interest in this particular matter. Guys, remember, 13 people, 13 13 people died. And still, Aboshamila Batohi have gotten away with this. There's also, not just did these people, the KORK panel, overlook the High Court judgment with regards to this matter and withdrew charges without consulting the prosecutors in terms of the SCA judgment. What makes the matter worse is that witness statements were overlooked and were named as hearsay. So there's the witness statement of Matonzi, who was the witness in the taxi association. Because remember that, as I've said in my previous videos, these people, after unaliving these people from the taxi association, they would receive certain rewards. And these rewards, at most cases, were in cash, in a form of cash. They receive sometimes even millions of rands. And that's one of the problems about this whole thing, of which, from what I've explained about racketeering, these people who benefited a lot from unaliving, and they got monies from the taxi association. And people who were witnesses, including Matonzi and Ndlondlo, who were both later on unalived, they deposed of affidavits to show an exchange of money between taxi association and Mr. Booysen. And still, the panel was still not convinced. They were like, that's a hearsay, because remember, these people are no more. And this also, another affidavit from Mkize, who's confirmed that the acts of Booysen were unlawful and he was unaliving people. And all these people, guys, it just so happened that in the middle of the trial, they got unalived. And they said their applications were not going to be successful because either way, this is hearsay.
You've got two witnesses. We went through Mr. Matonzi's statement. Mr. Matonzi was present when the money was collected. And he was present when it was said that the money is for Mr. Booysen. The only thing he didn't witness is the exchange, but it was witnessed by Mr. Ndlondlo.
Of course.
So where is the hearsay? I don't understand that.
It's not hearsay. I was answering, even if it's said to be hearsay, it shouldn't be a problem.
Yes. Now, when they are talking about a hearsay statement, I mean, is that a misdirection?
It's a misdirection indeed.
Because that seems to be direct witnesses. I mean, there was, of course, a problem that Mr. Ndlondlo was subsequently killed after he gave his statement. And Mr. Matonzi was also killed after he gave his statement. And Mr. Bongani Mkize, who, and I also don't understand the thing about Bongani Mkize. He was a deponent in an affidavit which Major General Booysen criticized some aspects that they were hearsay. But all of those were then subsequently confirmed by the direct witnesses who were present when people were killed. So even in relation to that affidavit, it's unclear why it was regarded as hearsay.
It couldn't be hearsay, especially the one that would have been made in the process of court proceedings.
Yo, guys, this is worse. And what makes the matters even worrying is that the panel failed to look at legislation or case law authority of South Africa. They looked at Florida. You can't look at international law without exhausting domestic law. And Riley came with a very shady and awkward excuse regarding their reliance on international law instead of South African domestic laws.
This statement, I found it remarkable. The people that are writing this are saying the investigations are incomplete, but then they recommend the withdrawal of the charges. What is your comment on that?
It's very unfortunate and improper. With respect, it looks like my colleagues did not go in depth into the evidential material that were contained in the case dockets, because you can't say an investigation in respect of Mkize's death and investigation in respect of KwaZulu and investigation in respect of Magojela and in respect of the Biela brothers is incomplete. It can't be.
This has left us with a lot of shock because they didn't care about anything, this panel. They didn't even care by the fact that actually this information was obtained through torture. People that testified and actually were saying, these people that were unalived were acting unlawfully and they were a threat to the police, hence they were unalived, were actually tortured for them to actually say that. I think I did make a video about one of the people from the taxi association who's still on the run even to this day, who was one of the people that came and in a way sold his brothers because he was being tortured and unlawfully arrested.
Because the authors of this report is Mr. de Kock, Mr. Tenga, Ms. Riley, Mr. Mamabolo. These are senior employees of the NPA.
Yes, in defense of the accused.
Whatever they were trying to do, whether they're doing good or bad, the fact of the matter is that information obtained through torture is unconstitutional. This is what used to happen under apartheid.
Indeed.
Now you have here the 4 senior prosecutors together with the National Director of Public Prosecution. They hoist this report around, but it's relying on information obtained through torture. And they don't tell anyone that there is a trial that declared the information inadmissible.
Very unfortunate.
Yes.
And when you look at this whole thing, there were 23 ballistic reports. And Mr. Stays provided 10 ballistic reports. And which means that not all ballistic reports were actually considered from MANGENA. And that's what makes this whole thing shocking. Before I can even go to MDLULI, guys, I wanted us to finish Cato Manor, as I've said. The testimony of Major General Mabula. So Major General Mabula says that he was called by Advocate Ramat, who was like, you know what, I need you guys to help me. Advocate Mabula is actually not even from KZN. He was deployed from whatever province that he's coming from to come and actually assist with this case in KZN. And he says that he then assigned different people from different provinces, Limpopo, Northwest, and all of those people, so that they can assist with formalizing or finalizing this particular report. And one of those was Kambulani Kuba. Kambulani Kaba, if not Kuba, if I'm not mistaken. And Kumbulani was part of the people that assisted. He's from Hawks, and they helped with this investigation. One of the things that they've realized with this particular investigation is that, number one, they were followed. They were surveilled and using the AVL system by the Cato Manor unit. That was the first red flag. And they even had to incorporate Lieutenant General Mkhwanazi to assist them to protect their investigation, because at that time, they were just very vulnerable to this Cato Manor unit. Remember, these people, they're unalive, they don't care.
I'm saying the facility. Which facility is this?
The facility is where we actually housed our TESTIFY and so on. It was at the task force, KwaZulu-Natal SAPS task force offices.
Yes.
So they actually provided us with a strong safe where we put in all these years.
And that was facilitated by General Mkhwanazi?
Yes, correct.
What does that mean?
It means that there is possibility of interference into these investigations. The work that we are doing is not really, how can I say, it's not really recognized. And then, there's a disruptive element that want the facts not to be divulged to the public.
Yes. And the only people that would have that interest in suppressing the evidence from surfacing would be who?
It would be those who are involved.
Which is who?
Which by then allegedly would have been Cato Manor.
Yeah. And they found out that there's a lot of misconduct after their investigation from Mr. Booysen, and that there were shady or mysterious circumstances in how these people were unalived. Because remember, to those who don't know, these people were unalived because of the unaliving of Superintendent Tongo and the unaliving of Inkosi Zondi. And they wanted to find the people that might be the suspects in this particular case. But the most shocking thing is that these people were not apprehended. All of them, they were unalived. So here, they concluded that Booysen failed to comply with court orders and must face disciplinary proceedings. Alternatively, this alternatively constituted a common law offense. Guess what? To this day, Booysen, even though he's retired, but they were not disciplined. They didn't go through disciplinary proceedings.
No one actually took disciplinary steps. These people must be suspended from work. Their firearms must be taken, and then they must be taken through a disciplinary hearing.
No, in that period, no.
Yes, that's what I was asking.
Yes.
All right.
And one of the biggest questions was who at that time was the National Police Commissioner? And others were saying it was Piecha, others were saying it was Mkwanazi. It's not clear who was the National Police Commissioner, but that person is the one that definitely has to come and answer and tell the public as to how was it that the Cato Manor unit was able to unalive people, and the disciplinary proceedings were suggested by the special task team to investigate the Cato Manor, just like what is going on at the Madlanga, the special task team that has been formed. It came with recommendations, and those recommendations were not implemented because none of those people were actually disciplined. Instead, they were let go off. They went free as if nothing happened. And of course, even this Major General also faced some prosecution for doing this investigation. He was charged with 11 counts, and it didn't end well for him.
Entrenched within the system that these people you were dealing with were very powerful and they could retaliate.
It is powerful people. It's powerful people because I can say many times my name was flung all over the news. You link with the same as Advocate Chauke City here, the same as Advocate Mahema, because of, and they always refer to the same case. Those are the people who did this. It's always the case. But because we have got this thin skin and we are actually loyal servants to the state, it didn't actually deter us up until we have to appear before the judge on 11 counts of charges now. You know, it's not very easy to appear before the judge. It's very difficult. I've experienced that.
Well,
now comes the juicy testimony of Advocate Shareen Riley. Shareen Riley, guys, is so weird because she's part of the KORK panel. But that's the thing. One of the things about the KORK panel is that these people just relied on statements. It's like they pick and choose the evidence that they wanted to rely on for them to make the conclusion that will make them happy or the conclusion that will protect Booysen. Hence, one of the things that Advocate Nkabinde said, you guys, I don't know what Booysen has on you that you want to protect him so much, because indeed they actually wanted to protect Booysen so much with their everything.
Ask on what you worked on. That's not my question. I am reading to you the document because I'm going somewhere else, not where you think I'm going.
That is correct, if based on the document, yes.
Precisely. And then we go back to where the document starts. Major General Booysen rewards these officers on the strength of this document. Remember the reward I started with of 10,000 rands, which is page 2250. Now this is in circumstances, they sit there in the office, they're paying themselves money. They have a document that shows clearly that a fleeing suspect was shot and Mr. Ndimande, who posed no threat to them, was shot and killed. You want to seriously tell me that Major General Booysen did not know that this was illegal at the time he took the money and he approved the money for the others?
I don't know, what am I supposed to say in terms of this document? This document is not the evidence in the docket.
I'm not talking about the docket. You remember what we are talking about. We are talking about an enabler of unlawful activities being Major General Booysen. You kept on saying, show me the evidence. I told you that, wait, I'll show you the evidence. I've now shown you the evidence. You are shifting the goalpost now, talking about the docket.
It's also very important to also state that Miss Riley is also not from KZN. She is in Cape Town, but she was asked about an opinion regarding a case or a unit that is in KZN, which is the same thing that Chauke did from Johannesburg to KZN, but there's a problem with Chauke doing that, but with Riley, nothing is wrong. So this report started by circulating, right? It circulated. They had set down this panel, this the KORK panel that is made out of Riley and other prosecutors, including the KORK. So they decided to write this report or this recommendation, and that's the thing. The draft itself was the one that even reached the president before they even finalized it, to a point that the document that reached the president does not even have Riley's signature. So. But still, Riley said that yes, the draft does echo her thoughts, echo what they wanted to begin with. But that's the thing, that shows you the unprofessionalism from them, because this document does not even show as if it's a final document, it just seems like it's a draft. And the fact that they missed out on a lot of things that were in this docket just shows you that indeed this was a draft. They submitted a draft to the president of South Africa to decide on someone else's future. Yo.
Correct, yes.
And at that date, everyone else understood that it was still a draft.
That is correct, yes.
Now, if you are, hence I'm asking you, ma'am, if you are able to, I know you can't speak for Advocate. The Kock is not here to speak for himself. But to the extent that you are able to shed any light, please do so. Are you able to shed any light as to why would Advocate the Kock sign a draft document, knowing very well that it is a draft, purportedly on behalf of everyone else, and send it to Advocate Batohi? Would you know of the reason?
No, I don't know.
Yes.
To the report signed by Advocate de Kock? No.
Now, the report that you guys considered on the 1st of July, were there any other changes?
No.
Yes, so the report remained the same.
That is correct, yes.
Yes.
So here, as I've said, they didn't want to rely on the High Court judgment. They didn't look at the High Court judgment. They forgot to look at the High Court judgment. What is worse is that in terms of the poker, they made conclusions based on partial or half evidence, if you want to put it like that. Even when Abrahams, because Abrahams is the one that came with a report in a way that exonerated and protected, or in a way didn't find Chauke guilty. But that's the thing. Shamila didn't want that. Shamila wanted all these prosecutors to pay and didn't care about what Adam said, hence found the KORK panel, which found in her favor. And here, she said that there was nothing. She found nothing that could deem Booysen as someone who's guilty. Mind you, as I've said, if you followed these proceedings, you followed this channel, you'd see how brutal the unalivings happened in the Cato Manor unit. And she says that there was nothing wrong. When they were looking at the evidence, there's just nothing that showed that Booysen acted unlawfully or that he should be found guilty.
In relation to the Cato Manor issue is your report, correct?
If I read the charges, that is correct, yes.
Yes. Did you recommend that he should be charged with misconduct?
No.
Yes. And so that was a decision of the NDPP, not your decision.
Because I wasn't involved in that decision.
Yes. Now,
I beg your pardon? What's the answer?
well, can you repeat your answer, Advocate O'Reilly?
I wasn't involved in that decision.
And your recommendation is made a decision. That decision is then set aside by the High Court. On the logic of Advocate Batohi, you would be guilty of misconduct.
I'm not guilty of misconduct. I disagree with you.
No,
I was part of a panel of 4 people. We were requested to review the evidence, which we did, and we made recommendations to the NDPP. We did not tell her to follow those recommendations.
I understand precisely. That's exactly what happened to Advocate Chauke. He was not a decision maker. The decision maker was the NDPP. He is charged for recommending and supporting, which is precisely what you have done. And he is also charged because he comes from Gauteng and is involved in matters from KwaZulu-Natal. You come from Cape Town, you are involved in a matter in KwaZulu-Natal. So it seems to me that it's hypocritical for you to say, no, you should not be charged, but Advocate Chauke should be charged.
I didn't institute any charges against Advocate Chauke. I never said he should be charged. You are there, you are incorrect.
I see. So you would agree then that it would be wrong to charge Advocate Chauke merely for making a recommendation which is not binding on the NDPP?
I did not make the decision. Neither do I know on what basis that decision was made.
I understand that, but if you want us to go through the terms of reference, we can do that. It's clear on what basis the decision was made. I'm simply testing whether there is consistency inside the NDPP's office. That's why I'm asking you that you cannot be a hypocrite. it is either you agree with me that if the MK party succeeds, you should also be charged with misconduct, or you say, I don't agree with you, in which event that applies to you and it applies to Advocate Chauke. It's as simple as that.
It's not as simple as that. Like I said, in our line of work, we make decisions every day. We also ask for opinions, and this was exactly what has transpired, to make a decision on recommendations to the NDPP.
They put it to her that Booysen knew of how these people were unalived. There was even a hit list that Mkhize told us about, who's no more as well. And he knew how people were, and he knew that his actions were unlawful. But according to Miss Riley, there is no evidence in the dockets that says that Booysen were killing people for rewards. That's the thing. There is another article that was released by Times Live, if I'm not mistaken, that said actually Booysen rewarded these people after they unalived that guy on the streets who was like, I think he was not even in the streets, he was on a freeway with his car. They came, they fired at him. And according to them, that was just, not a reward, and people were just unalived. That's all. And as I've said in the beginning of this video, she said that that was a form of resolving a case. He said when people are unalived, like those suspects were, you've resolved the case. Even the sisters there, because they call themselves sisters, which is the commissioners, in a way, if you want to put it like that. They were shocked about Nkabinde. They're like, really? We thought that in South Africa you have to go through the channels, the legal channels. Then the legal channels are the ones that will determine if whether you're guilty or not. But according to Riley, people unaliving you as a suspect in a road, nowhere, where no one sees you, that is them resolving a case closed. Yeah.
First thing he must ask himself, why did you gentlemen shoot a fleeing suspect? But no, he approves the payment, he pays himself as well.
Do you have any comment, Advocate Riley?
I don't agree with the submission by Advocate.
When you look at the Mkhize matter and the Quasi matter, Ndlovu, the 16-year-old who was unalived, Padiache was guilty. It was said that Padiache acted unlawfully. And that is the High Court. I'm talking about the High Court judgment. And also, the Mangena, I'm talking about the Mangena reports. So the Mangena reports, they look at the case of Mkhize amongst many, and the case of Quasi. And in the case of Mkhize, they found out that actually Mkhize did not fire. There was no self-defense case at all. And that Mustaf was supposed to be found guilty because they must be prosecuted because they acted unlawfully. It's the same thing with the Quasi Ndlovu matter, the Eskawini matter.
They never engage with it.
Indeed.
They never engage with, these are the findings of Mr. Stale, and this is why they are wrong.
Yes.
Yes. And they are also not telling the truth about what they relied upon, because Mr. Mangena primarily relied on being present at the crime scenes. The idea that they were so distant, they say it was photographs, post-mortem photographs and other statements in the docket. But Mr. Mangena's evidence was that he visited the crime scenes himself.
Yes.
He didn't just sit in an office and then rely on statements in the docket.
Yes.
And Mr. Mangena's evidence was that he spoke to some of the witnesses. Yes.
So with that particular Eskawini matter, Padiache was supposed to be prosecuted from the reports of Mangena. And then the other evidence in the dockets. She then obviously disputes that evidence. She says that it was not sufficient because the Mangena reports are talking about a possibility, but don't give evidence. I just gave up because these are ballistic reports. These are ballistic experts, meaning they do certain tests. But according to Miss Riley, these are just possibilities. Guys, yeah, South Africa, I get it.
That is exactly what I said. If he was not on the crime scene, and if he provided any information regarding the tracking and tracing of a suspect or handed over that information, it was part of his duties as a commander or another police officer. Because I thought we also agreed that my submission was that I understand that that is the manner in which the police operate.
There was Lindelani Mkhize. and Misokulu statements, who are seeing these members actually planting firearms. Still, those statements, they did not consider them. They didn't care.
And then the police found a pump-action firearm lying between the mattress and the base. But we again know the story of these firearms, how they end up there. We have at least 3 eyewitnesses who saw the police planting the firearms.
Yes.
Members, there were 2 Biela family members that were unalived, and Mangena had reports on that. They overlooked it. They didn't care.
That according to the evidence of Advocate Shaun Abrahams, Captain Mangena had done 19 reconstructions. Correct?
If I understood it correctly, yes, he did several reconstructions of the crime scenes.
No, he did 19 that were considered by Advocate Shaun Abrahams in the answering affidavit that you've referred to in your own statement.
I can't specifically remember, but I am not going to disagree if that's what the statements say.
Look at SR 0271. Paragraph 539.
That is correct, yes.
And that's where the number 19 comes from. Can you say that?
That is correct, yes.
Now, it is only a person who doesn't care about what they are doing who will pick 5 reports out of 19 for analysis. That's the point I'm making.
If 19, they were not all 19 dockets that form part of the indictment and the prosecution memorandum. If you can tell me that is what it is, the 19 out of the 26 dockets, then I will agree with you. But you need to be able to show me that there were reports. How many reports were in those dockets?
Well, this is exactly why we have included all of the reports in the cross-examination bundle, which you did not consider. I'll give you the names now of all of the reports that were in the dockets that you didn't consider.
And that's the thing. She doesn't even want to agree that what motivated these people was the cash, was the money. They continued with the killing because they knew that after the killing, they're going to be rewarded. 1,750,000 rands. Those are the monies that they received. There's actually that 10,000 monetary reward that I spoke about was a Times Live magazine or interview or newspaper that disclosed Booysen actually paying these people as part of their reward for unaliving these Cato Manor unit members.
That is correct, yes?
Yes, and the candidates to be rewarded, the first candidate is Director Booysen, correct?
That is correct, yes?
And they are all rewarded for allegedly solving the Mapumulo case, correct?
That is correct, yes?
The Kock panel overlooked the fact that there is 28 unalivings in total, but only 24 had warrants of arrest, meaning the other 4 had no warrants of arrest. The other 4 had warrants of arrest. 24 no warrants of arrest. And the Kock panel didn't see anything wrong with that. Riley and the rest, they saw nothing wrong with that. And one of the questions was, why didn't it ring in your mind that the people that are being killed, the people that are being unalived the most here, they are black people? And she said race is irrelevant.
Have a group primarily of white men, Van Tonder, Lockham, Mostert, Booysen, executing African men. Didn't this play a role in your evaluation about the possible explanation? The reason I ask you this is because Merity Haas wrote a letter to Advocate Batohi and asked in the letter, if the deceased had been white, would you respond in such a careless fashion? She never got a response to that. And I ask myself this question, even to yourself. If the deceased had been a different race, would you be so nonchalant in the way you have dealt with them?
I don't agree with your term nonchalant. As I explained it on several occasions, we studied the docket. That is my role as a prosecutor, to look at the evidence in the docket. So I do not agree that it was done nonchalantly. I have submitted SR5, that is our work document, in which we looked at each and every docket that were given to us, the 26 dockets.
Because that's the thing. if you look at the testimony of the people that told us before, including Denicus, they were using even the word K, you know, and even Mary DeHaas wrote to Batohi and complained about the fact that the massacre that is happening is mostly focused on the people of color. And the report didn't see anything, and the KORK panel didn't see anything wrong, right? Didn't see anything wrong. She said, this is not about race, and that is irrelevant. And according to Riley, there were no ballistic reports in the dockets that they read for them to give Batohi the recommendations without even her reading even one docket. So that's the thing. They erred. They made errors. Because when they were reading the dockets, they only found 6 ballistic reports, even though in total there were 9 ballistic reports. They didn't even care. They only found 6. They didn't even care about the rest as to where the others. They didn't even ask, even though there were studies that showed that there were actually 26 dockets and 23 is part of the 26 dockets, and that there were 6 reports instead of 19 reports. They didn't care. Abrahams made it clear, because remember, there was an Abrahams report which had everything that they didn't rely on. Then they went, put the report aside and made their own report. Their Abraham's report said that there were 19 reports, ballistic reports, but they didn't go and ask themselves where the rest. They only relied on 6 ballistic reports, of which for them, those ballistic reports are just possibilities. They are not evidence. Hi guys.
Yes.
Yet, you knew that according to the evidence of Advocate Shaun Abrahams, Captain Mangena had done 19 reconstructions. Correct?
If I understood it correctly, yes, he did several reconstructions of the crime scenes.
No, he did 19 that were considered by Advocate Shaun Abrahams in the answering affidavit that you've referred to in your own statement.
I can't specifically remember, but I am not going to disagree if that's what the statements say.
Look at SR 0271.
That is correct, yes.
And that's where the number 19 comes from. Can you say that?
That is correct, yes.
Now, it is only a person who doesn't care about what they are doing who will pick 5 reports out of 19 for analysis. That's the point I'm making.
If 19, they were not all 19 dockets that form part of the indictment and the prosecution memorandum. If you can tell me that is what it is, the 19 out of the 26 dockets, then I will agree with you. But you need to be able to show me that there were reports. How many reports were in those dockets?
Well, this is exactly why we have included all of the reports in the cross-examination bundle, which you did not consider.
More than anything is the fact that they used the American laws. They used the UK laws. And those Florida statutes that they used instead of South African statutes, I think are the ones that made them to make this error. I don't know if they're the ones, but they made a huge error because they didn't even see these rewards as part of the things that have enabled Mr. Booysen to continue with these unlawful acts.
What you've referred to is Anthony Watts versus the state of Florida. It took the definition from the statute and put it in the judgment. That's why I ask you again, why did you use the statute of Florida and not the statute of South Africa?
Because how they define what 2 incidents are assist us with a pattern of racketeering of activity in our definition.
But can you not see that it's plainly different? Because in Florida, it must be 2 incidents. That is why they say, if it is 2 crimes from the same incident, that amounts to 1 incident. In South Africa, the word incident is not used, but the word offense is used.
That is correct, yes.
Can I come back then to ask you the question? Why are you applying Florida law when we have clear South African law?
If you can refer me to a South African case that deals with this issue rather regarding the planned, ongoing, continuous or repeated participation, then I will agree that there are differences. But my understanding was, in terms of proving a planned and ongoing, continuous, a repeated participation does not refer to a single incident, because the idea is, regarding a pattern of racketeering activity, is that you are involved over a continuous, ongoing, repeated participation in these offences.
They even failed to see that 8 people were killed, were unalived for Superintendent Kongo. They failed to even see that 3 were unalived for Inkosi Zondi. 11 bodies in total, and all of these bodies are high-profile bodies, and Booysen was in charge of these cases directly because he was an overseer and also signed those letters of rewards. That is what is going on, guys, in our country. We have prosecutors that if they feel that they don't have enough evidence against you and that they can't prosecute you, they ensure that they go and fish for international law to find you guilty. What has happened to Advocate Chauke is really unfair. And what this commission has proven, or this inquiry has proven, is that that man didn't do anything wrong, and that everything he did was justified by the course of laws. But Batohi, together with the KORK panel, which had Advocate Riley, they felt like they're above the law, and that there's no law that will subdue them to anything or any behavior, and that all times, at all costs, what they want is going to happen. And they ended up doing unlawful acts, including relying on unlawful laws to make a conclusion about Advocate Chauke, and ended up making a serious error that will always make the NPA look bad. I'm still shocked and in awe of the fact that killing someone is resolving a case, and the fact that even a suspect, you're not even a person that actually, you're just a suspect, and they have just breached the Constitution, which says you have the right to life. But to them, that breach is just resolving a case. There's nothing wrong with their acts. I just think that these are the people that the inquiry is supposed to be created for. Chauke didn't do anything. As I've said, the reason why I'm justified in saying that is because the courts have decided that he didn't do anything wrong. I know this is going to be a long episode, but I just wanted us to quickly look into the case of MDLULI. So here, there was a Harley SC opinion about the SCA judgment. And this SCA judgment literally doesn't see anything wrong with what Advocate Chauke did. So what Advocate Chauke with the MDLULI case is that I think there was a case of an unaliving. So this unaliving, it involved a lady called Tidi Buthelezi, who was the girlfriend of MDLULI. And I think it was just relationships gone wrong. Ukel moved on and MDLULI was not happy with that. And Timba, I think he's sort of like a police officer, I don't know if he's close to MDLULI or what, said that MDLULI was involved in the Buthelezi case. So according to Batohi and her people, they felt like there was overwhelming evidence, or suggested strong evidence instead of circumstantial evidence, that they should prosecute Mr. MDLULI. However, what then Mr. Chauke did is that he dropped the charges, and after he dropped the charges, he felt like an inquest was better in this matter than just proceeding with the prosecution. And I think that didn't touch them well, that the charges were withdrawn, and then they instead took the inquest position, because according to Batohi, that weakened the state's case. But the SCA said that Mr. Chauke's decision was not irrational. And this was post-inquest actions that ended up making him to be in trouble. Even though they tried to question him with which right now we're still going to hear if they're going to succeed with that application, because the state wants to bring the application that they should look at pre-inquest decisions that Chauke took. But the biggest problem of Batohi was the post-inquest decisions that were taken.
We look at this letter. It is dated the 14th of March 2012.
Yes.
And it is your formal request to the magistrate to conduct an inquest. Do you agree?
Yes.
And if you look at paragraph 3 of that instruction to the magistrate, you set out a list of names of witnesses.
Yes.
And the list is quite extensive.
Yes.
Amongst the list is, I just like to highlight this. Amongst this is the brother of the deceased. We find him at F. And there are also certain police persons, such as in M and in X.
Yes.
The MDLULI case, with regards to the MDLULI case, we're still gonna hear the testimony maybe of Harley and other people that played a role in either charging or exonerating Mr. Chauke with regards to the decision that he took with MDLULI, taking the inquest route instead of prosecuting him. I don't know, guys, what you think about this. As I've said, for me, it gets to show you the brutality, the evilness of the NPA. NPA, guys, is so evil. And I think they're definitely working with these people that are called the Nkabi and all of that. Because to them, it doesn't matter. As long as you're unalived, when they've resolved the case, it's over. They don't care. The fact that you cannot look at ballistic reports, you can just say it's a possibility and you don't care, gets to show you how to them it didn't matter. The lives of all these men, including a 16-year-old guy who was just sitting and watching a TV, whom they went to and unalived. The brutal unalivings that were happening to Black African brothers. To them, it didn't matter. They didn't do the due diligence. Instead, they went, because they wanted someone to say they acted wrong. They went and looked for international law, Florida law. They looked for Florida law to justify their action. For the longest of time, it seems like that worked for them. Nonetheless, guys, I'm not gonna lie. I'm not shocked. I'm shocked. I don't know how to feel. But at the same time, you as the viewer, you decide what you do with this information. I know it was a long episode. I've been banking this episode because I wanted to have an all-rounder, a once-off episode where we talk about what has been happening at the Nkabinde inquiry. Very interesting, I must say. I love everything going on. I love when the criminals and the NPA and how they're working together in cahoots to make people go away and do the acts of criminality and move on without even being held accountable. Nonetheless, guys, let me hear your thoughts. Let me hear what you think. I will see you guys on my next upload. Bye.